My lord, I beg to mention an item to take up as an unlisted item, my lord, because there is an auction to be scheduled tomorrow, my lord.
Tomorrow
Tomorrow.
we'll pass an order.
Meet with the Lordship. Lordship, I beg to mention for item number 10, Lordship, 10. A similar matter has been fixed on 20th June. So I may pray for fixing the same on 20th June. It is a part heard matter, Lordship.
Similar matter, what is the case number?
Case number, item number 10, Lordship, and similar, case number 31 of 24.
Similar matter is.
Similar matter, Lordship, writ appeal, 428 of 23.
You're Mr.
C. Kumar.
Mr. C. Kumar and counsel appearing for the writ appellants submits that a similar matter being writ appeal number 428 of 2024
24.
is pending before this court.
23, Lordship, 23.
Matter is
Apple 23.
pending before this court and the appeal is fixed on
20th June. 20,
June
20th. 20th
2024.
June 24.
As such, this matter be listed along with the aforesaid appeal. Since the prayer is not opposed, same stands alive. Allowed registry to do the needful for listing both the appeals together.
Obliged, Lordship.
May I please, your lordship, with the consent of the other party, I beg to mention item number 8. The matter may be taken after 2 weeks, your lordship.
After vacation.
After, okay, highly okay.
You are for the,
I am for the petition, your lordship.
on the prayer of learned counsel for the writ appellant made with the consent of the other side. This matter stands adjourned. This case again after the ensuing summer vacation. Yes.
Highly.
May I please, your lordship? With the consent of the other side, I beg to mention item number 5, lordship. Maybe taken after vacation, lordship. I have taken consent.
5 is connected with 6, no.
No.
You are appearing for?
I am for respond number 31 and 32, GA Mizoram, lordship.
You have informed the other side.
Yes, I have
Yes,
also
I'm
submitted.
I'm for the respondent.
I am appearing for the appellant on behalf of Mr. Eskil Majid.
Sir, police police.
Take down, a request for adjournment in this case. Adjournment of hearing of this case has been made on behalf of the learned government advocate of the state of Mizoram, appearing for respond numbers
31 and 32.
31 and 32. Since the prayer is made with the consent of the other parties, the same stands allowed. Let this writ appeal be listed again for hearing after the summer vacation.
Lordship, similar prayer in respect to item number 7 also. I have taken consent of the appellant.
Yeah, for the appellant. And item 7, lordship, we are for the appellant.
Mr. A. Borua, learned senior government advocate, state of Mizoram, appearing for the respond number
50 and 51.
50 and 51, has made a prayer for adjournment of hearing of this matter with a request to post the case again after the summer vacation. Since the prayer is not opposed by Ms. L. Devi, learned CGC, appearing for the writ appellant, the same stands allowed. Let the matter be listed accordingly. Yes.
Obliged.
May it please, your lordship. I beg to mention for listing of a writ appeal for tomorrow, your lordship.
Tomorrow not possible.
Your lordship, the urgency is it relates to a minor child promotion.
Hmm.
So your lordship may kindly consider.
Tuesday.
Your lordship, then keep it on 20th because I will be out of station for my personal difficulty.
Item 1.
May I please, your lordship. Lordship, as for last order, we were supposed to furnish a detailed factual report, your lordship. Waiting for the report. Kindly some time may be granted, your lordship. In the contempt proceeding, your lordship, so that we can.
How much time?
2 weeks time, your lordship. Sorry, my bad.
Mr. R. Gogoi, learned standing counsel, Forest Department, submit that the report required to be filed as per the order dated 29/5/2024 passed by this court. In these proceedings was not yet ready and therefore, 2 weeks further time be granted for filing the report. Full stop. Mr. T.J. Mohanto, learned standing counsel, GHC, is present and does not have any objection in the prayer. In view of the above, let this matter be listed again after the immediately on reopening of the summer vacation. In the meantime, the report as called for be placed on record.
Am I right, your lordship?
Item 2.
May it please the Lord. Lord will kindly first take the page number 77.
Yes.
Kindly see, my lord, estimated cost at page 77. Towards the bottom of the box, 1 crore 50 lakhs 34,198. Then my lord will kindly come to page 79. What is the scope of the work? 2A, providing male and female security guard for round the clock security on the campus at the designated places, etc., etc. So estimated value of the work is 1.5 crore and manpower requirement is 150 plus. Now, my lord will kindly come to page 86. And see, my lord, are these required? Page 86. Now, serial number 1, how the experience should be evaluated. Executed a single contract up to the 10 crore 10 points. Executed single contract value above 10 crore 20 points. Now, those who are in the line of business up to 5 years, 2 marks. So this is a somewhat okay. We may not have any grievance. Now, annual turnover of the company, any of the last 3 financial year, up to 100 crore 5 marks and between 100 crore to 200 crore 7 marks. Manpower on payroll up to 5,000 5 marks, above 5,000 10 marks. Now please come to 7. Certification of CAPSI, that is Central Association of Private Security. It's a private body. For that it carries 5 marks. Now, end of the day, I think some presentation has to be made in the form of some interview and some subjective satisfaction would be derived by the authority. Now, kindly see, my lord, is it not a case where even playing field has totally been obliterated? Why? CBC guideline says, if you are supposed to do a work of 1 crore, if you have experience of 30 lakhs, it's good enough. Now, the moment a player who has got executed single work of 10 crores and above, he will get 20 marks. Where do the local firms stand? Now, is it not irrational?
What does the learned single judge say?
No, learned single judge says that your lordships will get page 232. Last sentence at page 31. In view of the issue raised by the petitioner in the criteria provided for the technical bids, we may examine the same. It is seen that for experience in the work concerned, tender up to would get 10 marks for executing a single contract up to the value of 10 crore during the last 3 financial year, and 20 marks for executing a single contract above the value of 10 crore. 5 mark has also been fixed for annual turnover of the company up to 100 crore in any year during the last 3 financial year, while 7 mark is fixed for annual. Possibly kindly skip to 2-3 lines, then the sentence starting with, therefore, from an overall appreciation of distribution of marks and its criteria for earning the same, one can say that there is no restrictive clause. So the learned single judge view is these clauses are not restricting your participation. But it may not restrict my participation. End of the day, where do I stand on the face of these clauses? Does it ensure level playing field? It does not. So basic view of the learned single judge is that these are not restrictive clauses. Even with your experience, you can also compete. But that's not the thing. End of the day, I must be in relevance. If I am not in the know.
What is the stage of the tender?
Lordship, that the tender has been opened and it is awarded to Lordship
When?
on 5th of June. This is the record. 8 tender participated, it was evaluated,
and we move this honorable court on 3-0. 3-0. Filed it. And on last occasion, my lord, my learned lordship would recollect, my learned friend was not even there. when the matter was listed on Monday. Nobody was there. We could have pressed that case on that day, but having regard to the fact that he was not there.
And company chart is also there, lordship.
Right. তার আগে একটু দেখাবো four.
Mr. Chaudhary, work order has been issued on 5/6 in favor of one GDH security.
No,
solution.
Milord, now, rightly or wrongly, we have brought to your lordship's notice the aspects. Before that, if your lordship will kindly permit me to two small paragraph from page 86 and 7, how eventually the evaluation was done, Milord. If your lordship is
So,
satisfied,
all right, all we are saying is, why don't we file a.
of course, we'll have to
it
do
on
that.
18th.
Do
We'll fix it on 18th.
18.
Yes, 18th, we'll fix it. By tomorrow, you file the amended.
And my lord, that will be subject to the outcome of the case. Award of the contract.
18th or 19th, we'll fix it.
But let it be 19 million. Now, there is a requirement of securing minimum 70 marks. That is there at page 87. Page 86.
We don't heard Mr. K. N. Chaudhary and senior counsel listed by Mr. N. Dekan and counsel appearing for the writ appellant. Also heard Mr. S. Sigmund, Planet Standing Counsel, Tejpur University, appearing for the
Respondent number 1 to 4.
respond numbers 1 to 4. Mr. B. Chakravarti, Learned CBC is present on behalf of respond number.
Central committee is not a party.
Yeah. You are for 1 to 4, all the
Yes,
respondents?
yes.
All right, for all the respondents, full stop. Assailing the judgment and order dated 16/5/2024, passed by the learned single judge in WPC number 956/2024, rejecting the challenge made by the writ appellant as petitioner to certain clauses in the NIT dated.
Yes. 24/2.
24/1/2024, issued by the Tejpur University.
Sorry, 15/2.
No, NIT is 24/1/2024.
15/2. Earlier. 15/2 is the impune NIT.
15
At page 76.
15/2024. For the purpose of awarding the work of hiring security personnel in the Tejpur University, the instant writ appeal has been filed, inter alia contending that the terms and conditions contained in the impune NIT are onerous and have been deliberately inserted so as to eliminate the local bidders. First up, Mr. S.C. Kyle, Learned Counsel for the respondents, on the other hand, has produced the departmental file to submit that on processing the tenders, work order has already been issued in the name of the successful bidder, namely Messrs. GDX Security Solutions, SOLUTTIONS Solutions Private Limited, having its office at east of Kailash, New Delhi, and therefore, without hearing the successful bidder, the writ appeal cannot be heard on merit. At this stage, Mr. Chaudhary undertakes to file amended cost title in pleading the successful bidder if leave is granted by this court. Prayer is allowed. Leave as prayed for by the appellant is allowed. The appellant may file amended cost title in pleading the successful bidder as respond number 5 within tomorrow, subject to compliance of the above condition. The writ appeal will be listed for orders, listed for admission again on 19/6/2000.
Much.
Subject to so and so in view of the urgency expressed by the appellant's counsel, the writ
And
appeal.
will be subject to the outcome of the case.
That order will be passed on 19th. Because you may get a stay order for all you know. Why you want to preclude your client?
Item 11 and 12.
May I please your lordship?
Yes.
Lordship may pass over for time being
There is
lordship.
another matter, two matters are there.
Yes.
We'll issue notice and
No, my lord, I am praying for a, at least so far as my appellant is concerned, there is no grievance against me. Where are the materials before the?
so appellant, both of them are still working.
No, then if status quo is maintained, it's okay. My lord, we have worked for 9 years.
No, that's right, that's right. We will, I think that matter was there.
In fact, my lord,
Mr. Kalita, where is he?
Lordship is in court number 13.
Tell him that there is a code number 5 or 6 also.
Lordship,
You tell him the order we are passing. All right. We'll have to examine this matter.
yes, yes.
Because these are certain other dimensions also. I remember I was in the bench the other days. Keep on. Equity of the issue.
It was 2003 NFCC assessment. 2003.
3 points. So, seem to remember, suspicion of. But,
That's what we are.
All right. Yes. We'll stay the operation of the order. Or we can set it aside also today if you want.
Lordship, let him appear, Lordship.
All right. Let him come.
One.
We may hear and finish it off today itself.
Yeah.
Obliged.
For hearing item 3.
Lordship, the petitioner side is not here.
What is this matter?
Lordship, the PL has been filed seeking something, basically want some implementation of the CS, the Chief Commissioner Security reports, Lordship. We have implemented everything, Lordship, whatever is, some deviation which has been permitted by the Railway Board. Some, that is all, Lordship will find in our affidavit, Lordship. Based on that, 4-member committee, expert committee, we have taken undertake steps, Lordship. Lordship may put in some other day. He is not here, Lordship.
None appears for the writ petitioner when this matter was called up for hearing today. Mr. B. Chakravarti, learned CGC appearing for the respondents, stroke railway authorities submits that all security measures as per the instruction of the Railway Board and the superior authorities for the, this is what Guwahati Silchar railway segment has already been implemented in letter and spirit, and therefore the relief paid for in this PIL no longer survives for consideration by this court. Be that as it may, since the petitioner's counsel is absent today, this matter is directed to be posted again in the 4th week of July 2024 for passing appropriate orders.
Item 2. Item 4.
Count as a,
Yes.
my role is not there.
Is rain responsible for this?
I got-
Councils are not present.
No, whatever.
We'll have to pass it over then,
Lordship.
Today, whether you also.
whether it's,
Rain.
whether it's good or bad.
There,
Depends on who is-
Otherwise good. But for coming to court, it is very bad.
Depends on what time of the day. Now
Because
appears for the writ
only
appellant
jammed
on call,
technically.
Mr. P. Nayak, Learned Standing Counsel, PWD, as well as Mr. C. Borwa,
Accountant.
counsel for the respondent general are present. Since the appellant's counsel is absent, the matter stands passed over. List again after summer retirement. Is there any urgency in this case?
But subject to outcome order is already there.
Item 6. But as per earlier order dated 5/3/2024, my lord, there was order for with regard to the steps for direct recruitment to the post of principal, whether it's to be taken or not. That is the order there. That the NCT, sorry, my lord, the Autonomous Council, the Dimahasa, my lord, they have told that they are not the authority to Director of Secondary Education who is to take the steps for.
I have not been able to follow what you are saying.
My lord, the issue is with regard to the, my lord, the posting of in-charge principal in the is government higher secondary school, my lord, in the Dimahasa, my lord. And last occasion, this honorable court asked, instead of deciding the issue, matter was my lord, whether the regular promotion to the post of principal is going to take place and as to when it will take place. In that regard, my lord, the Dimahasa Council has stated that they have forwarded the list and it is up to the Director of Secondary Education to take the decision, my lord, to complete the process. That's why the information is order was there to take the instruction. Otherwise,
that was only an offshoot of the writ appeal which my friend had filed. What had happened is he was appointed as the in-charge principal. The private respondent, they challenged it and ultimately there was a replacement. Now, what had fallen from the court at that point of time, the regular appointments should perhaps bring a solution to the problem. But my lord, so far as the writ appeal is concerned, we have taken the reservation policy has been now allowed by the department, and now we are finalizing the gradation list. Otherwise, the writ appeal, my lord, that can be argued on its own merits, whether he had a right to continue as the in-charge principal or not. That is the only. He was initially appointed as the in-charge principal, then there was a replacement by the appellant because he had in the meantime qualified to hold the post of principal and he was senior to the private respondent. Private respondent challenged the same on the ground that there could not be a replacement of an ad hoc by an ad hoc. The ad hoc and ad hoc concept in charge does not flow in according to the department. If a senior person is qualified, he can replace the junior person. That was the stand of the department. That has been negated by the learned single judge on one hand, and second hand, my lord, he was qualified per the rules to hold the post otherwise. The learned single judge has held that he was not qualified to hold the post by ignoring one sub rule of the rule 15, my lord.
Rule 12.
So therefore, rule 12. Therefore, my lord, this writ appeal perhaps needs to be heard on its own merits. And the regular promotion process will of course carry out. There is no difficulty in that.
This is listed for hearing today.
Hearing.
Argo?
my lord, the impugn order, my lord,
Yes. Impugn order is
at page, it starts from page 158, my lord.
158.
Yes, sir. The Honorable Single Judge, my lord, while taking the decision, has taken into consideration the Rule 12(3)(a) and 12(3)(b).
Let us read the order, please.
Yeah.
Order is 23/3/2022.
Yes, sir. Shall I read my relevant or
No, it's a short order. We'll read the whole order.
yes, sir. By filing this writ petition under Article 2 to 6 of the Constitution of India, the petitioner has assailed the impugn order dated 30/6/2020 passed by the Principal Secretary NC Hills Autonomous Council, Respondent number 1, allowing the Respondent number 6, namely Shamir Majumdar, to hold the charge of the principal of Government Girls Higher Secondary Schools, Haflong, thereby replacing the petitioner, and for passing consequential order dated 17/7/2020 passed by the Respondent number 2 to allow the Respondent number 6 to take unilateral charge of the post of principal, and the petitioner is also seeking a direction upon the respondent to allow the petitioner to hold the charge of principal of the said school as per previous orders dated 31/8/2017 and 10/10/2017 till a regular principal is appointed. In brief, the case of the petitioner is that on 29/12/1999, when she was appointed as subject teacher in Government Girls Higher Secondary School, Haflong, by the respondent number 2, the petitioner had already acquired her degree MA, BA, MA, and BEd. And in course of service, she had clarified a NET, MPhil, and also acquired her PhD. The petitioner had joined in the said post on 31/12/1999. Her service was regularized on 12/1/2006. It is projected that as per instructions of the Inspector of Schools, the in-charge principal of the said school, who was superannuating on 28/2/2017, handed over the charge of the post to the principal in charge, which is projected to be in consonance with the circular dated 18/3/2015 issued by the Director of Secondary Education, Assam, after the senior most subject teacher had refused to take over the charge as principal owing to his ill health. The respondent number 1, by an order dated 31/8/2017, gave approval of the name of the petitioner for appointment as in-charge principal, and thereafter, by an order dated 10/10/2017 issued by the respondent number 2, the petitioner was temporarily appointed as an in-charge principal of the said said school. The respondent number 2, in the meanwhile, promoted the respondent number 6 to the post of vice principal of the said school by order dated 13/1/2020, and thereafter by an order dated 30/6/2020. Impugned herein, the respondent number 6 was appointed as an in-charge principal of the said school. The learned counsel for the petitioner has submitted that the respondent number 6 had obtained his BEd degree by off-campus mode without taking any prior permission and without authorization by UGC DEB, and therefore it is submitted that BEd degree could not have been accepted or recognized as a valid degree for the purpose of employment and obligatory promotion to the next higher post of secondary education department, and that the order of promotion of the respondent number 6 was in total violation of the office memorandum dated 18/1/2020. It is further submitted that at the time when the petitioner had thereafter the respondent number 6 was appointed as in-charge principal, the provisions of the Assam School Service Government Secondary School Rules 2009, hereinafter referred to as the Rule 2009 rules, was in force, and that the said rules was repealed with the publication of the Assam Secondary Education Government School Service Rules 2020, hereinafter referred to as 2020 rules. The official gazette on 3/6/2020. It is also submitted that the respondent number 6 did not have the requisite qualification to be appointed as principal, and therefore it is submitted that the respondent authorities could not have appointed the respondent number 6 as an in-charge principal by replacing the petitioner who was already holding the post as in-charge principal. Per contrast, the learned standing counsel for the KSC has made her submission to justify the appointment of the respondent number 6 as an in-charge principal. She has made an attempt to produce the records relating to appointment of vice principal to demonstrate the procedure allowed for making such appointment, and has submitted that the same procedure was followed to appoint the respondent number 6 as an in-charge principal. It may be mentioned that the court has refused to look into such record for 4 reasons. Firstly, the appointment to the post of vice principal is not the subject matter of the adjudication. Secondly, the court had not passed any order to call for any record from KSC. Thirdly, as no document was annexed to the affidavit in opposition, by looking at an unsolicited record, the petitioner would be taken by surprise. Fourthly, no reason was shown for not being able to produce the records relating to selection and appointment of petitioner as an in-charge principal. Records relating to her removal for appointing respondent number 6 as an in-charge principal. Thus, the purpose of producing unsolicited records appears to be doubtful and for oblique purpose. Per contra, the learned counsel for the respondent number 6 has submitted that the respondent number 6 was admittedly senior to the petitioner. It is submitted that while the respondent number 6 was appointed as assistant teacher, that is for up to class 10, on 28/1/1992, and his service was regularized on 24/11/1994. The petitioner was appointed on 31/12/1999 as subject teacher. that is for classes 11 and 12. Her service was regularized on 12/1/2006. It is also submitted that while the petitioner never served as vice principal and was directly appointed as in-charge principal, whereas the respondent number 6 was appointed as vice principal by the order dated 17/1/2020, where he joined on 30/1/2020, and that the respondent number 6 was appointed as in-charge principal on 30/6/2020, where he joined on 27/2020. It was also submitted that the petitioner was non-STH category candidate by birth, and after her marriage to a STH category person, she had illegally acquired scheduled tribe certificate as STH. In this regard, reference is made to various documents appended to the affidavit in opposition and additional affidavit in opposition filed by the respondent number 6. Accordingly, it is submitted that as per the 2020 rules, there was no impediment to appoint the respondent number 6 as an in-charge principal. At the outset, it would be appropriate to mention that classes and cadets are prescribed in Rule 3 of the 2020 rules, as per which the principal would come within the cadre of Class 1 Assam School Service Selection Post, and the vice principal falls within Class 2-1 category cadre, and the post of postgraduate teacher and subject teacher falls within the cadre of Class 2 Roman 2. The provisions relating to the recruitment to the post of principal by promotion and criteria thereof is contained in Rule 12 of 2020.
All right, you can skip this part of the rule. Come to para 8.
In the present case in hand, the undisputed fact is to the effect that the respondent number 6 was appointed as an in-charge principal by the impugned order dated 30/6/2020. Therefore, as the 2020 rules was published in the official gazette on 3/6/2020, it must be presumed that the respondent authorities must have undertaken the exercise to appoint respondent number 6 as vice principal as per the mandates of 2020 rules. Therefore, as the respondent number 6 is not found to fulfill any of the essential criteria as prescribed in the Rule 12(3)A and 12(3)B of the 2020 rules, or to be appointed as the principal, the appointment of the respondent number 6 as an in-charge principal is found to be unsustainable on fact and in law, because as per the requirement of 2012 Rule 12(3)A, the respondent number 6 has not been able to demonstrate that he had rendered at least 5 years of service as vice principal, or that he had rendered 15 years of service as postgraduate teacher in any government higher secondary school. It is seen that the petitioner was temporarily appointed as an in-charge principal of the said school by the order dated 10/10/2017, issued by the respondent number 2. Therefore, the said appointment had been made under the erstwhile 2009 rules, which was then in force. The petitioner is found to hold the requisite qualification to be appointed to the said post as per Schedule 2 to this said 2009 rules, read with entry number 3 Assam School Service Junior Class 1 at row number 2 of Schedule 1 relating to class cadre strength of each cadre and scale of pay. It is also seen that the respondent number 6 was appointed as vice principal under the 2009 rules, but interestingly, the learned counsel for the respondent number 6 has not been able to show that under the 2009 rules, the respondent number 6 as vice principal had any scope for being promoted to the post of principal. Thus, the learned counsel for the respondents have not been able to demonstrate that the petitioner lacked of the prescribed criteria and experience to be considered for being appointed to the post of principal in charge of the concerned school. It is too well settled principle of law that one ad hoc cannot be replaced by another ad hoc incumbent. One of the leg of argument is that the petitioner was not a STH reserve category candidate and that she had procured such certificate illegally. In this regard, the respondent number 6 has not been able to show any law in force that a non-STH candidate is disqualified from holding the post of principal of the concerned school. In this regard, the court is of the considered opinion that the writ petition filed by the petitioner on no inquiry or adverse to her interest can be gone into when the validity of such certificate is not the subject matter of the adjudication. Therefore, if the respondent number 6 has any grievance with the STH certificate obtained by the petitioner, he may be well advised to seek appropriate remedy before the forum competent to decide on the validity of such STH certificate. Therefore, in the light of the discussion above, the court is inclined to hold that the petitioner has been able to establish his right to continue as an in-charge principal of Government Girls Higher Secondary School, Haflong, and has been able to establish that the respondent number 6 let the eligibility under Rule 12(3)A and 12(3)B of the 2020 rules to be considered for being appointed to the post of principal. As such, the petitioner has been able to demonstrate that the respondent authorities could not have appointed the respondent number 6 as an in-charge principal in the place of the petitioner. Thus, this writ petition succeeds and the same is allowed. Consequently, the impugn order it is such and such passed by the Principal Secretary NC Hills Autonomous Council as hereby thereby allowing the respondent number 6, namely Samir Majumdar, to hold the charge of the principal of Government Higher Secondary Schools, Haflong, by relieving the petitioner, namely Dr. Bobita Engtupi, a subject teacher, from the additional charge of principal is set aside and quashed. The respondent number 1, that is the Principal Secretary NC Hills Autonomous Council, is directed to pass consequential order within a period of 3 weeks from the date of service of a certified copy of this order to allow the petitioner to hold the charge of the principal of the said school as per previous order dated 31/8/2017 and 10/10/2017 till a regular principal is appointed. The writ petition is allowed to the extent as indicated above with order as or with no order as to cost.
So who is the in-charge principal now?
I am the in-charge principal now.
There is a stay of the order.
Yes, in this order, there is stay, my lord. In this writ appeal, there is a stay. And in the writ petition, there was no stay order in favor of the private respondent, my lord. And since then, I am continuing as the in-charge principal of the school, my lord. My
What
lord,
is wrong with this order?
wrong is there, my lord. May I take your lordship to the rule? Rule 12(3)(c). There are 4 conditions. The Honorable Single Judge,
Page number?
page number 67 in this book, my lord.
Rule 12?
Rule 12(3), there are 4 conditions, my lord. I fall under C, my lord, which says 17 years of service as graduate teacher in any government higher secondary schools to become the principal in charge, to become the regular principal. The Honorable Single Judge, my lord, while
When was the writ appellant appointed?
I was, my lord, I was appointed, my lord, on 24/1/1992, and I joined on 28/1/1992. And private respondent
24/1/1992
92,
and joined on
28/1/1992. And my lord,
you are appointed as what?
as graduate teacher, my lord.
Is the copy of your appointment order there?
Yes, I will produce.
Which page?
Appointment order, my lord, page 27. The type copy 28 is the.
So according to you, rule 12(3) sub-rule C,
Yes, I fulfill, my lord.
under that you qualify.
Yes. And I
What
was
about your B.Ed degree?
B.Ed degree, my lord, already there is order from the government, my lord. My B.Ed degree has been accepted by the government. My lord,
Where
page
is the order?
55, page
Page?
55, my lord.
Order dated?
Order dated, my lord, 6/1/2021, my lord.
Yes.
And I have all the qualifications for holding the post of principal on regular basis. And she is junior to me, my lord. And she has been appointed on 31/12/1999.
appointed on 31
31/12/1989.
as subject teacher.
Yes, Lordship. As per Rule 12, my lord, all
Where is the order of her appointment? It's in the record,
that, my lord,
page 59. Is it page 59?
it is my promotion order, my lord. Page 15 is my promotion order. And seniority list is there, my lord, at page 56. That will show, my lord. Comparative. Thirty-one 12/1999, her name at serial number 4, page 69, my lord.
Page 69.
69, my lord.
All right. Yes, anything else?
And my lord, since then I am holding the charge, my lord, and I am senior to her, my lord. And as per rule, my lord, I am otherwise qualified and eligible, my lord. 2009 rule has already been repealed, my lord, and after the enforcement of the 2020 rule, my lord, and I have been given the charge. As per the rule, existing rule, I am the qualified senior most teacher. That's why, my lord, I am holding the post, my lord. And therefore, the authority has given me the charge. After coming into new rule into force, my lord, they have given the charge. New rule has come on 8/5/2020.
New rule?
Has come on 8/5/2020, my lord. And I've been given on 36/2020.
New rule was published in the Gazette on 3rd of June. Is it?
My lord, at page 57, it is date is given, my lord, 8/5/8 May 2020. In the
When was it published? Published on 3rd of June.
third of-
And rule 1, sub-rule 3, it shall come into force on the date of the publication in the official gazette.
Published on 3rd June.
And I've been given on 30th June, my lord.
All right. Yes, who is appearing for the department, private respondent, yes. So what is your case?
My lord,
Senior has B.Ed degree then?
My lord, when the post of in charge principal is lying vacant, my lord. At that time, my lord, 2009 rule was in force, my lord. 2009 rule says that the assistant teachers are not within the zone of consideration for promotion to the post of principal, my lord. Lordship may kindly have a look at the 2009 rule for a moment. That is
Yes.
2009 rule.
Yes, which provision?
In this book, my lord, my lord,
Page number?
page 777, my lord, in this book, my lord.
777.
Yes, my lord. In the rule 3, my lord, at page 779. The principal of higher secondary and multipurpose school is the seniors selection grade post. Then, my lord, class 1 junior vice principal as well as the postgraduate teacher. Then, my lord, assistant headmaster are senior class 2, assistant teacher are senior class 2. My lord, kindly have a look at, my lord, the schedule appended under this rule at page 7, 8, 9. Schedule 2, cadre and qualification.
Yes, what do you want?
My lord, kindly have a look, my lord, schedule at page 789, cadre and qualification. Name of the post principal of higher secondary schools, NT qualification. Members of Assam School Service Class 1 Junior with 7 years of teaching experience in the cadre. My lord, the vice principal, secondary school, then postgraduate teacher, 10 years experience. Then, my lord, I am only, my lord, drawing lordship's attention to the eligibility criteria, NT qualification for the principal. That means he should be a class 1 junior cadre, means he should be either postgraduate or vice principal with 7 years experience in that cadre. So, my lord, at that time, he is an assistant teacher. In 2017, the post of principal was vacant, and he was assistant teacher. I am the subject teacher. So, I am holding the eligibility criteria to be considered for the post of principal as per the settlement. So, my lord, the post 2017 when it arose vacant, the principal has taken step, and lordship will find in page 98 of the writ petition, annexure 2A. Annexure 2A.
Yes.
This is a letter of the then principal, outgoing principal. He is writing to the inspector of school, asking to whom the post may be handed over. My lord, may I read, my lord?
Page number, page?
Page 98. My lord, some problems, my lord, pages given, copy given to me is not little, my lord.
No, you go by your page number.
My lord, annexure 2A, annexure 2, Roman 2. Annexure Roman 2 in the writ appeal. It is letter dated 28 February 2017.
What is the page number, Mr.
98, my lord.
90. Here, my lord, the outgoing principal asking the inspector of school to hand over the charge to Sri L.K. Deka, senior most subject teacher of the school today on 20th February 2017. Then, my lord, L.K. Deka, my lord, he refused to take the charge. That is his letter to principal, page 99. That he is not.
What is the relevance of all this?
My lord, then, my lord, there was an seniority list of the subject teacher. My lord, there is a guideline of the government, my lord. That is annexure Roman 1, page 97. In the light of the rule of 2009, there is a guideline, my lord. Lordship may kindly have a look at page
Mr.
97.
Sekhar, what is your argument?
My lord, my argument is that the 2009 rule specifically excluded the assistant teacher for consideration of the promotion to the post of principal. At that time, he was assistant teacher. I was the subject teacher. As per the rule, my lord, the then rule,
That's right,
I am
but
eligible.
They have changed it after the new rules have come.
My lord, in the change the new rule, but the new rule has not excluded me, my lord. I am also eligible. The rule 12B of the 2020 rule says that a subject teacher rendering 15 years service is eligible. He is made eligible, but I am also eligible.
Okay.
Then, my lord, my consideration is that since I am also eligible and I am holding the post of in charge principal for at that time 3 years, and the specific order by which I am allowed to hold the post of in charge principal, that is in page 100,
So therefore,
And-
you don't agree with the learned single judge.
my lord,
You are also eligible, he is also eligible.
eligible, my lord.
But learned single judge says he is not eligible.
My lord,
You are, then you are
my
not
lord,
defending.
that
your-
may be a mistake by the learned single judge. I agree, my lord. But my lord, how I can be ruled out, my lord? How I can be ruled out? And the order of page 103, whereby I was given charge, that order specifically stated, my lord, may I read out, my lord, in page 103, the my lord, last paragraph. Dr. Bobita Angtibi, PGT, Gov Cards High School, Higher Secondary School, Uplogging is allowed to act as in charge principal of the school temporarily. In addition to his her own duties, till a regular principal is appointed by the government or until further order. My submission, if any final decision, a regular arrangement has been made and thereby he is considered, I have been left out, I have no grievance, my lord. This order says that during the final process, I may not be disturbed.
All right, yes,
That is my submission, my lord.
okay. Okay. Yes, Mr. Majumdar,
And also, my lord, I have also relied one judgment.
judgment, what is there in?
Judgment, my lord, the state of Haryana and others, my lord.
Pyara Singh.
Para 46, my lord.
Pyara Singh, state of Haryana.
Yes, my lord, yes, my lord.
That's not applicable here. That is ad hoc service. This is not ad hoc service. All right, you keep
My
it,
lord.
for now you keep it.
My lord,
We'll mention about you.
my
It is
lord,
not applicable here. Okay, you want to hand over the judgment?
my lord.
State of Haryana versus Pyara Singh.
Yes, my lord.
Oh, that's a completely different judgment, different context. But you give it, we'll mention it. Which paragraph?
46, my lord.
Jagannath.
Yes, Mr. Majumdar.
My lord, there is a judgment of this honorable court, Jagannath Pegu, which says that the senior most eligible teacher will hold the in charge position.
Give it.
So
Where is it?
even if my learned friend's arguments are taken to be correct, the appellant remains the senior most eligible teacher. And since it is not a case of ad hoc replacing an ad hoc, the senior most teacher had the right to claim.
Where
the
is
in
that
charge.
Jagannath? The Jagannath.
I have
the
in
appeal itself.
the connected miscase, it is at page number, my lord, 45. IA number 293.
Page number?
45, relevant portion at page 48, my lord, paragraph 9 and 10.
There are 9 and 10.
Petition. Para 10. It is apparent that the petitioner is senior, the response number 4 is graduate and eligible in terms of the rules for being promoted the post of promoted the headmaster. In the absence of any material record to justify the impugned order, I am not inclined to sustain the submission made on behalf of the official respondent. Noticeably, the official records pertaining to a decision preceding the issuance of the impugned order have also not been produced to support thereof. It is too fundamental to state that a candidate eligible in terms of the relevant rules for promotion to a post of regular basis cannot be overlooked for the purpose of any temporary arrangement concerning the post of the instant case. In absence of any affidavit controverting the correctness and authenticity of the statements made in the petition, is permitted to proceed on the basis that the pleaded case of the petition is correct. Relevant rules.
Yes, what else?
Therefore, my lord, the charge was given to the appellant. And the 2009 rules should not apply because the post was being considered in 2020 rules.
Order reserved.
My lord, one short submission. One small. Kindly have a look at, my lord, rule 33 of the 2020 rules.
Yes, it will avoid it.
By that provision, it is said that any decision taken under 2009 rules cannot be, my lord, held illegal, my lord. 33, my lord. 33 up to 2020 rule.
33. 33 isn't it? Page number?
My lord, it is
78, my lord.
it is
No, it 18 says, I believe.
78, my lord.
78.
78.
yes, my lord. It is 70. Repeal and saving.
Oh, repealing. All right,
My lord.
yes. We'll dictate the order in the chamber. No, no, no.
I think 9.
Dispose of. Dispose of. So original records are there.
Lordship.
Original records are there. Have you got the records?
Lordship,
There is an order that original records.
Lordship, I have submitted the notification by which the DRT Guwahati was substituted, Lordship. That must be in the.
No, Mr. Chakraborty, there is an order of 22/6/2023.
Regarding Lordship, establishment of the. Lordship. Regarding-
Status quo is maintained. as of
Status
now.
quo is- here.
You are working?
Here only he is continuing here.
Continuing, Lords.
Terms of deputation is long over, Lordship. He was appointed in the advertisement of 2015 years, advertisement clearly stated it would be on deputation.
All
but
right,
we-
now, we understand there is urgency. We'll hear it, but, do you have the records?
Regarding Lordship,
We find that the Lanet single judge in 22/6/2023, division benches
means the
observed.
notification by which the DRT was considered, that was supposed to be produced, that I have submitted, Lordship, notification.
Hmm? Do you have a copy of the order dated 22/6/2023?
20,
22/6/2023.
right now it's not.
Just have a look. Just have a look. This is para 7.
Just, Lordship, only one, in what aspect the record has to be produced, that's it.
Have a look. Have a look.
Yes, Lordship, that notification is with me, Lordship. I have that notification.
Do you have the records in terms of para 7? If you have it, fine. If you don't, if we hear it, we'll not adjourn it.
Sure.
Either we'll take it that record is there or it has not been produced. If he agrees to waive that requirement under clause para 7, then also we have to follow the procedure. It is not like, all right, let's do something, let us forget it.
Lordship,
That
just in
doesn't happen.
respect of the notification that has to be.
All right,
produced,
so therefore that is the only record.
Lordship.
So we'll proceed on that. If there is If it goes against you, it goes against you, Lordship. But after that, there will be no chance to produce record, Lordship. That's all we are saying. After hearing the matter for half an hour, 45 minutes, I'll produce the record. That opportunity will not
Lordship,
get.
my submission is very simple, Lordship. I am relying on section 3 of the
In the
DRT.
prayer of Mr. B. Chakravarti, learned counsel for the petitioner, this matter is directed to be listed again on 24th of June 2024, so as to enable him to produce the relevant records. Mr. S.C. Kyle, learned counsel for the respondent is present. Mr. Chakravarti, why are you going here? Either you say no further record is required.
Lordship,
You say that record will talk about this, my submission is this. What is the meaning of this kind of argument?
Lordship, record was in respect of the establishment of the DRT.
So all right, then you strike it. No further records, no time will be given
That
for
will
any.
not be
Yes.
necessary, Lordship.
Huh?
Record will not.
Then
be
we'll
necessary.
continue, but we'll not adjourn it for record.
Lordship.
If the record are necessary, we'll record that it was not produced despite order. So there will be an adverse presumption. You have to agree to that.
Lordship.
Then it's fine. We'll dispose it of. Yes, give it. Yes.
Lordship, where the appointment of the respondent is on deputation that has been ordered to be treated as a promotion by the CAT, Lordship, on the premises that he is a departmental candidate, because the advertisement said that departmental candidate will be considered to be, in case of departmental candidate, will be treated as a promotion. That your Lordship will find at page 21, the advertisement, Lordship.
Page 21.
21.
Yes.
It clearly says it is on deputation, but note 2, Lordship, second column, Lordship.
Hmm.
It said that for the post of section officer, departmental candidate having requisite qualification shall be considered along with outsider in the case of departmental.
So what is the post? Which post is this?
Section officer, Lordship. Now, Lordship, we come to page 22, his appointment order.
Just a minute. So petitioner was working as what?
Respondent was working as
I
an
mean
assistant
respondent.
at the DRT cutoff.
He was working as
DRT cutoff as an assistant.
As an assistant.
We issued an advertisement calling for appointment on deputation, but with a rider that the departmental candidate will be treated as a, in case of departmental, it will be treated as a promotion. Now, Lordship, his appointment.
He was a departmental candidate.
No, in our case, this is not, because that each of the DRT till 2018 were a respective area of jurisdiction. And they have their own recruitment rules, Lordship.
So
Since
here,
2000
who will be the departmental candidate? Only those working in
But
DRT
the
Guwahati.
DRT Guwahati will be treated as a departmental candidate. But the Learned Cat held that since it's all under the Ministry of Finance, it will.
All right. Now, you maintain a cadre of this assistant section officers, right? Is it maintained zone wise or it is?
Till 2018, it was DRT, respective DRT, because Lordship find from the recruitment rules, Lord, that I have enclosed, Lordship.
Followed, what we are asking you is, this seniority and cadre, etc., is maintained zone wise.
Zone wise, means each of the DRT has their own. The cadre strength of DRT Guwahati is cadre, one section officer, Lordship.
So it is a single post cadre.
Single post.
Show us
Till
that.
2008.
Show us the record to show that.
Lordship.
Show us the record to show.
It's from the recruitment rule, Lordship.
Where is it?
Lordship, I haven't.
Recruitment rule will show what is the cadre of Guwahati, DRT Guwahati.
Lordship,
Mr. Chakravarti, you are inviting for some.
Lordship, in the schedule, cadre strength has been shown, Lordship.
All right.
Page 24 is the recruitment rule, Lordship. The relevant page, Lordship, I'm sorry that the relevant page has not been typed, Lordship. Page 36.
Page
36.
All right.
At the bottom, Lordship, section officer. At the bottom, Lordship, section is, I'm sorry, Lordship, this page has been omitted, not typed, Lordship. Rest of the pages has been typed, Lordship.
What is this? What is this document?
This is a recruitment rule, Lordship.
Start from page 24.
Start from 24 and the hard copy is page 32, Lordship.
No, these are recruitment rules of Guwahati, DRT Guwahati.
DRT Guwahati, Lordship.
Where is it mentioned?
Lordship, page 32. bottom, short title and commencement. This rule may be called the Debt Recovery Tribunal, Guwahati Group, Group B gazetted and Group B non-gazetted post recruitment rules, Lordship. And the Lordship will, the strength is 1, Lordship, at column number 2. Now, Lordship will come to page 2018, rule is Lordship, I have enclosed at page 40. Since 2018, all the DRT of Lordship, Eastern Zone Lordship, up to Vizag Lordship, Visakhapatnam Lordship, they have been clubbed together and single rule has been framed, Lordship. Page
All
40.
right, yes.
Now, owners, Lordship, all that have been clubbed, and now the cadre strength has been shown to be 10, Lordship. That will Lordship find at page 43.
Page 43.
43. If the appointment would have been after 2018, he would have been a department.
So all right, now that the rules have been changed,
Lordship.
what is the problem in carrying out the order of the CAT?
Lordship.
Huh?
Lordship, can this is section 3 of the DRT Act, Lordship?
No, where is the integrated rule? Page number?
40.
Page?
40. Securitization Act, it was,
So all these rules of various recovery tribunals
and now have been clubbed together. Now the is the Calcutta Appellate Tribunal, they are the controlling Lordship. Lordship may kindly peruse section 3 of the DRT Act, Lordship. Establishment of tribunal.
Section 3.
Section 3, Lordship. May I read, Lordship?
Surface condition. You are referring to surface.
Recovery of debt. May I read section 3, Lordship?
Section 3, yes.
Section 3. The central government shall by notification establish one or more tribunal to be known as the Debt Recovery Tribunal to exercise the jurisdiction, power and authority conferred on such tribunal by or under this act. Subsection 2, Lordship. The central government shall also specify in the notification referred to subsection 1 the areas within which the tribunal may exercise jurisdiction for entertaining and deciding the claim. Now, Lordship, that notification under section 3, Lordship, that's perhaps likely to be in the record because I submitted on last occasion this notification by which the area of jurisdiction has been specified, Lordship. Initially, it was Sikkim was excluded, Lordship. Then thereafter, Sikkim was included. So Cuttack was never with a part of this DRT Guwahati, Lordship. So this is my humble submission, Lordship. He can be a departmental
So according
candidate.
to you, he
is
has
from
come-
Cuttack. He has a separate till 2018. This advertisement is of 2015, Lordship. And Lordship, can you see his appointment
So
order,
he
Lordship?
came in as a deputation or?
He came on deputation, the appointment order, Lordship, page 22. And he was drawing deputation allowance, Lordship. Page 22, Lordship. Bansidhar Mahapatra, Assistant of DRT Cuttack, is hereby appointed by the approval of Honorable Presiding Officer of this tribunal to the post of section officer in the pay band of so-and-so in DRT Guwahati for a period of 3 years on deputation basis or until further order. And the next page, Lordship, he submitted an option and he was drawing deputation allowance, page 23. So he can't be a departmental candidate of DRT Guwahati, Lordship. This is my humble submission.
He was appointed on deputation for how many years?
3 years, Lordship.
Where is it mentioned?
Lordship, in the order, page 22. Period of 3 years on deputation.
Oh, yes.
He accepted this drawing deputation allowance. This is my humble submission, Lordship.
And where is the operative part of the order of the learned CAT?
Lordship. At page 15, Lordship, the learned tribunal relied on the recommendation made by the
At page 50.
paragraph 15 at page 148, relied on the recommendation made by the presiding officer saying that he being the authority who set on the DPC as a chairman, so since he has recommended, is entitled. And the other point is relied that at page 17, he says that the tribunal held that this all are under the finance department, so he will be a departmental candidate, Lordship, at paragraph 17, Lordship.
So his period of deputation of 3 years is over.
Over, Lordship.
And now if he is reverted, then he'll be reverted back to
DRT Cutter
DRT Cutter assistant.
as assistant.
And what about his seniority?
Because
might have
Lordship,
been-
a combined seniority list has been maintained that I have annexed,
No,
Lordship.
no, Mr. Chakraborty. During the period while he was in deputation,
Lordship,
he might have missed out on promotional avenues.
Lordship.
What happens to that?
That will on the basis of the seniority, because four more person was senior to him in the combined seniority list published in the year 2019, Lordship. His position.
So has anyone junior to the petitioner been promoted as?
No.
Huh?
I have to take instruction. That is no.
It appears that he was on deputation.
Lordship, if you are mind to complete, I want to place some facts, Lordship. Lordship, I come to my affidavit, Lordship, page 161, paragraph 4.
Page 161.
Lordship. Paragraph 4. That while working at Debt Recovery Tribunal, Cuttack, as a assistant, the deponent can across the advertisement published in the employment news dated so and so for filling a post of the section officer in the Debt Recovery Tribunal, Guwahati. In the above advertisement, at note 2, portion of the advertisement, it was laid down, specified that post for, for the post of section officer, departmental candidate having requisite qualification shall also be considered along with outsiders in case the department candidate is selected. The post will be dated to have been filled up by the promotion.
All right,
Because-
these are okay. Come to the point. What is the point?
Lordship, I was working in the Debt Recovery Cuttack, Lordship,
Hmm.
and all the tribunals were under the Finance Ministry.
Hmm.
And Lordship, may please to see.
No,
my
but your appointment was on deputation.
No, Lordship, that's why Lordship,
You thought deputation means promotion.
Lordship, here because I was a departmental candidate.
Hmm.
And Lordship, there is
No,
a,
no, that's what we are asking you. According to you, because you are a departmental candidate, you thought deputation means promotion.
no, Lordship, Lordship, that was the problem, Lordship, because there was a litigation pending before the Honorable Court after my selection. And Lordship, may please to see how my case was recommended by that presiding officer DRT.
No, but did you draw deputation allowance or not?
Yes, Lordship, that was correct, but it was stopped and I'm ready to refund it back, Lordship. That, Lordship, may please to see.
Yes.
Lordship, page 162.
Yes, please.
Being eligible for the post of section officer and being a department candidate, that is from Debt Recovery Tribunal, Cuttack, the deponent has applied for the post of section officer at DRT Tribunal, Guwahati through proper channel.
Subsequently, the applicant received a call letter on 21/7/2015 from Debt Recovery Tribunal Guwahati for attending the interview before the
Mr.
selection.
Kyle, why don't you come to the point? He came by train, he appeared, he stayed in a
No.
hotel. Why do you want all this?
No, because Lordship saw that I applied through proper channel.
Yes, you
And-
applied through proper channel, but your appointment was on deputation.
Lordship, that was the reason. Lordship,
So why don't you tell us what is the point? Then we'll go into the details.
Lordship, page 165.
Please, you
Second-
read the brief. You are not, you don't seem to be well aware of it. Read it, we'll take it after 5 minutes. Because 162, 165, see, we are going to pass an order now. This is a serious
No,
matter.
Lordship, here.
You are shifting your stand again.
No, Lordship, I'm not shifting because my contention before Lordship that I was working in the DIT Cuttack as a in the Cuttack and I applied through proper channel. And because there was some litigation, my appointment was challenged before the Honorable Court. So this order was passed. And subsequently, when I made the petition before the presiding officer, my case was recommended for promotion. Treating him as a, and Lordship, another officer who was working in the DIT Calcutta, he was appointed in DIT Guwahati on promotion. If that is so, that all the DRTs are different and they are maintaining their different service role, then why one officer has been treated as on promotion when he came from Calcutta DRT Lordship? That was considered by the London Tribunal also. And Lordship,
Where is it? Source?
Lordship. Lordship, I may place the paragraph 15 onward, page 150, 148, paragraph 15 onward.
Is that person a party in this proceeding?
No, he's not a party.
Then how can we go into those things?
No, because Lordship, to draw analogy, when an officer working in DRT Calcutta, he was appointed in DRT Guwahati on promotion. Lordship, the submission of land, all tribunals are maintaining their separate rule till 2017.
Where is the order by which a DRT Calcutta person has been?
I have annexed with my Lordship may come to page 181.
Page 181.
Lordship. Serial number 1 and 8. One was working in Allahabad Tribunal. He was posted in Allahabad. And 9, he was working in DRT Calcutta. Krishnendu Mukherjee, he was appointed as recovery officer at Guwahati. And all the tribunals were under the Ministry of Finance. Yes, it is fact, Lordship, till 2017. There was a separate recruitment rule of all the tribunals. But 2018, all these tribunals has been combined and one rule has been 2018. In any case, Lordship, I will be governed by the 2018 rules subsequently, Lordship. Just for the sake of argument, we say that he was appointed in deputation. But since 2018, my position has been changed. And Lordship, this point was considered by the tribunal also. Lordship, page 150, 148. Since paragraph 15. Merit, Lordship, page 148.
Yes.
From the perusal of above rules vis-a-vis the recommendation of the presiding officer, who at the relevant point of time was the appointing authority, had made it clear that the applicant was appointed on deputation basis since one writ petition, Supra was pending at the time of his appointment, and for a long time, the aforesaid post of section officer was lying vacant due to non-availability of appropriate person. However, after promulgation of 2018 rule, all the DRTs were put under single rule to avoid any confusion, wherein it has been specifically provided that the departmental category who are in the direct line of promotion shall not be eligible for consideration of appointment on deputation vis-a-vis deputationist shall not be considered as eligible for consideration of promotion by promotion. It is observed that the applicant was appointed in such time when the recruitment rule was under process and changed after considering the factual difficulties to appoint on deputation within the different DRTs. However, it is the contention of the respondent that has to be accepted by the applicant was appointed under Rule 2001 of DRT Guwahati. In that case, the presiding officer is the authority who has to decide whether applicant would be treated as on promotion or as deputist, and in an instant case, said presiding officer after withdrawal of the writ petition by one incumbent, namely Sri Hariram Das, was of the opinion that the applicant to be treated as promotion. Even the subsequent recruitment rule also made it clear that the employees of all the DRTs under the same roof, departmental may place in different places, would be treated as promotee. In this case, K. Mukherjee Supra, also the finance ministry, had applied the same analogy and had treated said S.K. Mukherjee as departmental promotee, though that had come to from other DRT and on a different post. It is further observed that the applicant is guided by Rule 2001 of DRT Guwahati. In that case, the presiding officer is the authority to decide, and the chairperson of DRTs, who became appointing authority after promulgation of Rule 2018, has no authority over the issue which has come into existence after appointment of the applicant. Admittedly, applicant was working as assistant in DRT Cuttack, but applied for DRT Guwahati, and both DRTs are under the finance department and Group B officers of those DRTs. Therefore, working in different places cannot make him out of the department like any other department of the central government or the state government. Therefore, in our considered view, section and appointment of the applicant to the post of section officer would be treated as promotion instead of deputation with all consequential benefit. However, as the applicant has already availed the deputation allowance, he is therefore liable to refund back the said amount, or if it can be adjusted from its consequential benefit. This was the order, Lords. And admittedly, Lordship, K. Mukherjee, he was working in DRT Calcutta, Lordship. He was appointed in Guwahati DRT, Lordship.
So far as the K. Mukherjee's case is concerned, we have explained at paragraph, page 105 in our written statement, Lordship.
Now, first of all, what about this notification at page 181? J.S. Manrai and J.S. Manrai. Originally he was in which DRT?
He was, Lordship, the central government.
Lordship, this is the,
various tribunal.
in case of recovery officer, Lordship. Recovery officer are appointed by the Ministry of Finance, Lordship. They are not by the DRTs. That we have stated in our written statement, Lordship, page. Page 105, Lordship. Paragraph number 8. That Krishnendu Mukherjee's case was in respect of recovery officer. They are appointed by the Ministry of Finance, Lordship. That we have stated, Lordship.
All right, Mr. Kyle, you please get instruction whether anyone junior to your client has already been promoted to the next higher rank. We'll have the matter again on 19th. This bench is available. And after that, we'll close it. There is one obstacle we find here because as he said, they are all recovery officers. Recovery officer is not a part of the cadre in the service rule. So therefore, this observation of the DRT, the learned CAT, does not appear to be in consonance with the rules. Secondly, there is a direction to refund deputation allowance. So he was on deputation. He accepted it. And he accepted
That
the
is
allowance.
correct, Lordship. We are not denying that.
Correct. So after that to say that, sorry, I was not on deputation. Now, only thing we have to see is because his continuance on deputation, whether any prejudice has been caused to him, whether any junior has been promoted from Cuttack. That is the only aspect we would like to.
And Lordship, alternative argument, after 2018, the new rule has come, all the DRT has come together.
Hmm.
Lordship, what will be my position, Lordship?
Lordship, page 154 is still considered to be assistant because in the seniority list. Published in
You don't want to
2019
keep him here.
2019,
You
Lordship.
don't want to keep him in
Lordship
Guwahati.
is not working in the office.
Who said
That is
Lordship?
the-
Lord,
my
this is
instruction that,
a
Lordship.
very ridiculous submission, Lordship.
Because he was punished also, Lordship. He was drawing double rental allowance, for which punishment was also imposed on him, Lordship.
Lordship, they passed order, when the DRT case was pending before the DRT, they reverted it back. Then I approached the file application, then order was passed, I placed that order that is available on the record also. It's very ridiculous submission that I'm not working, and I'm working as a section officer
So
still.
those are not the issues here.
That-
No,
that-
Lordship.
those are not issues.
No, what we are asking you, Mr. What you are canvassing, you have done subsequently something which is completely contrary to that.
No, Lordship.
Yes, you have integrated all the tribunals.
Oh, that is in 2018, no? From 2018 onwards, Lordship. But
So-
in the seniority list is still shown as an assistant, Lordship. And there are 4 persons senior to him, Lordship.
Where, in which place?
Lordship. Page 154.
Page
This is-
154.
Lordship.
This
Refer-
is seniority list of assistant working in
Regular
DRT.
assistant, and his name is serial number 5.
So they are in DRT Kolkata, DRT Kolkata.
Now it's since 2018, all under DRT Kolkata, Lordship.
These people are still working as assistants.
As on the
This is the list of 2019.
2019.
So you also tell us whether these 4 people are still working as, get the instruction. It will sound. The recovery officer is included in the cadre, Guwahati.
Yes, it is.
That means this must be there in others.
Maybe.
Yes, it is there, Lordship.
Then why are you saying recovery officer?
No, he is appointed in a different cadre, much higher cadre. Recovery officer are appointed directly by the Minister
All
of
right, but
Finance.
the principle will be the same.
A principal will be.
Then
Oh,
if you have appointed other people or.
No, in his case, he applied, Lordship, and DPC said, and the parent department gave no objection, that we have stated in our written statement. And that was not followed in his case.
So for the petitioner, Mr. S.C. Kyle and a counsel for the, also heard Mr. S.C. Kyle and a counsel for the respondent. After hearing the arguments at some length, this matter is, the further hearing of this writ petition stands postponed till 19th of June 2024. So as to enable learned counsel for both the sides to obtain updated instruction.
Item 11 and 12.
See, I'm extremely sorry, Lordship, I was.
All right, Mr. Kalita, we will like to, we would like to examine these matters. There are, so in both these writ appeals, write a common order. Heard Mr. K. N. Chaudhary, learned senior counsel appearing for the writ appellant in WA number 195 of 2024. Also heard Mr. K. Goswami, learned senior counsel appearing for the writ appellant in WA number 180 of 2024. Both these writ appeal arise out of the common judgment and order dated 13/5/2024 passed by the learned single judge in WPC number 7767 of 2015 interfering with the selection and appointments of the REIT appellants in the post of junior assistant.
Yes.
Under the district industries and commerce center, Golaghat district. Uh, Having gone through the impugned judgment and order dated 13/5/2024, we are of the opinion that the matter would call for deeper consideration. First up, as such, issue notice returnable on 29th of July. 29th of July. Since Mr. Kalita, Learned Standing Council Industries Department has appeared and accepted notice on behalf of the official respondents, no formal notice is required to be sent to those respondents. Extra copies of the memo of appeal be furnished to the Learned Standing Council. The respective appellants to take steps for service of notice upon the private respondent by registered post with AD. Heard on the prayer of interim relief, we have noticed that the REIT appellants who are serving, we have noticed that in view of the, by the impugned judgment and order dated so and so, the appointment of both the REIT appellants who have been working for more than 9 years have been interfered with by the learned single judge. But there is no direction to issue order of appointment in favor of the REIT petitioner stroke private respondent. Rather, the direction is to conduct a fresh selection on the grounds due to the reasons mentioned in the impugned order. Having regard to the facts and circumstances of the case in its entirety and by balancing the equities, we are of the view that the appellants have made out a good case for granting an interim order. More so since both of them are still continuing in service. As such, we direct that the operation of the impugned order dated judgment and order dated so and so shall remain suspended until further orders.
Instead of more than 9 years, it will be almost 9. It will complete in.
Almost 9 years. Almost 9 years now.
Lordship, I have also prepared one synopsis of my argument and formulating certain points of my precise submission before this court. Lordship.
So you want to argue anything today?
Lordship, I just want to point out on that basis. Lordship.
Yes.
Lordship, in this case, that post which was advertised, Lordship, was Lordship motor vehicle inspector, Lordship. And that post is
So just a minute. The sum and substance of your argument
Lordship.
and the departmental counsel.
Lordship.
Sum and substance.
Lordship.
Say a person is master's degree holder in mathematics.
Lordship.
And in a particular recruitment rule, the qualification is BSc in mathematics.
Lordship.
So an MSc cannot apply because he is not qualified. That is the sum and substance of your argument. Is that correct?
That is Lordship.
Because the rule says BSc.
Lordship.
So an MSc cannot apply.
No, there is some certain point, Lordship. Suppose, Lordship, one thing we can take in this way. For acquiring a degree of MSc, one has to pass BSc. In that event, MSc presuppose BSc degree. Like Lordship, MA degree. For acquiring MA, Lordship, one must have to
pass B.Ed degree lordship. So in that event, there is a proposition that M.Ed is a higher qualification than B.Ed, and B.Ed was presupposed by M.Ed lordship. But unlike that case lordship, civil engineering, so far as this
All
case
right,
is
so
concerned,
in other words, you are saying BE in mechanical does not
no,
have the
lordship.
qualification of
yes.
diploma in mechanical.
Yes,
These are two separate things.
Yes, though there is a scope for lateral entry, or the subject prescribed in both syllabus are similar, it does not hold that higher qualification or BE can presuppose the lower qualification of diploma. The Supreme Court in this Catanab decision, which I have placed lordship, which relied on my friend also, I was just trying to distinguish that for presupposing, for academic presupposition and the presupposition in the context of recruitment rule lordship, two defined aspects, which I am trying to emphasize lordship. For presupposition in the context of recruitment rule, there must be lordship, recruitment rule must prescribe lordship, which Honorable Supreme Court has decided in that matter lordship. The Juti Keke lordship, which was past case in support of the petitioner, that BE higher degree holders was considered as a qualified for the post of sub-engineer lordship. In that case lordship, there is a rule 10, which specifically held, is prescribed that higher qualification also presuppose that acquiring the lower qualification. In this context lordship, Juti Keke case was allowed of the petitioner. But that Juti Keke was distinguished in subsequent judgment in Onita. In Onita case lordship, I will show your lordship on all those points lordship. Onita held that for presupposition of any lower qualification, the rule must specify lordship. This proposition has been held in the Zohur Ahmed also, very elaborately and distinguishedly lordship held lordship. Zohur Ahmed also further deal, suppose lordship even one candidate has some lateral entry in the higher course. Even Zohur Ahmed has discarded that proposition of argument and hold that for presupposing the any lower qualification, the rule must prescribe. Last judgment, Punit Sharma lordship, 2021 lordship.
Yes.
That Punit Sharma allowed the higher degree holder for the post for lower degree lower qualification, because by deriving an indication from the service rule that for the upper post or promotional post, that qualification was also allowed in the service rule, and government also subsequently amended the service rule. On that context only, Supreme Court hold that the higher qualification presuppose the lower qualification. Sum and substance, all these case lordship, as my humble submission, until and unless rule prescribed, this presupposition cannot be adopted by the lordship. The affidavit in opposition which AICTC has submitted, they have what they have stated. Both courses are similar. Yes, lordship, I am also agree. Both cases may be similar, but in the context of recruitment of any post, it must be provided in the service rule. And this is the second. Third argument, lordship, before your lordship, I am relying on the order passed by your lordship. That Kaushik Hazarika, which my learned pen has said, he has submitted my learned pen on a defined context. My context is that lordship hold, even if lordship after the advertisement, in that case lordship, Master in Energy Engineer claim that their course has also covered a post of diploma course lordship. And lordship hold, though there may be equivalent or that in the covering of those courses, but it is not the issue. Issue is that if court allowed at this stage, the similarly situated candidate who might have applied, had it was prescribed in the service rule or advertisement, they would be deprived. I submit that I am relying the judgment only in that respect only. So, lordship. And recently, lordship, another case also, Mumbai High Court, in Milind Shantilan Rathur case was also considered a similar aspect. Here also some degree holders has applied for that diploma engineering post, and their post was government has not appointed them. Their point was same, that as they were the higher qualified,
lower qualification is automatically presupposed. By discussing all these judgment from Jyoti Keke to Punit Sharma, the Honorable Mumbai High Court has decided that no, until and unless it conform the rules, recruitment rules, then only that presupposition concept would be derived. Lordship. And that was also went to the Supreme Court. Supreme Court was not inclined to grant stay and cases before the consideration of the Supreme Court. These are my lordship, sum and substance, lordship. And while lordship diploma and B is not equivalent or cannot be considered, in my written argument, lordship, in point number 3, lordship, I have stated by deriving it from the judgment of Allahabad High Court in lordship Deepak Singh, which my learned friend has already submitted that case. This is my argument.
Anything you want to say?
No, that deal also I have completed also.
You conclude. Anything in reply?
Not only my argument before your lordships in a very narrow campus, my lord. My submission before your lordships is that if it's in the same discipline, if degree is in the same discipline with the diploma, then it is presupposed. The Jammu and Kashmir High Court in Ramnik Singh, my lord, para 20, considered all the Supreme Court judgments and clarified that all the Supreme Court judgments, Jarur Ahmed, Anita, Latha, there was no such situation that it was in the same discipline. So that's why the Honorable Jammu and Kashmir High Court says it will be fallacy if a person who holds the degree in the same discipline will be not entitled to participate or get the selection. Second thing is that, Lord, in Jyoti Keke, my learned friend has mentioned that it is turned on in the rule. But in Jyoti Keke, my lord, 3 ratios were laid down, 3 regions were there. First region is that if it's in the same discipline, so it will presuppose. And the Honorable Apex Court, in the last line of that particular paragraph, said that we are not required to go further. Why? Because the rule itself provides. Second ratio is that in the higher post, not degree is a qualification. So why in the lower post it will be restricted? Third ratio is that had there been the intention of the legislature, then they would have debarred. Like in our High Court, we stopped class 8 pass for grade 4. So these 3 ratios, it's not the only ratio that it was turned on Rule 10. So in my humble submission, my lord, the judgment of the Jammu and Kashmir High Court in Ramnik Singh para 20 clarifies the entire issue. Apart from that, my lord, AICT also placed their affidavit wherein they say the course content as well as course content of diploma is subsumed in the degree. In fact, degree has more. I have also filed an affidavit giving your lordships detail, subject-wise, semester-wise, showing that the entire course of the diploma is subsumed in degree. And apart from that, the AICT also furnished an instruction before your lordships, which very clearly says that it presupposes. So in that view of the matter, my lord, my humble submission is that, my lord, there is no bar for your lordships, because even Jammu and Kashmir High Court also says that we are not required to read into it, because it's evident on the face of it. So in my humble submission, my lord, my humble prayer before our lordships is that these 4 petitioners out of 4 petitioners already cleared the test, passed, my lord. So they are required to be given appointment against the post earmark for them.
All right. Arguments, arguments concluded, judgment reserved.
The original record.
Records, what for? It's on law point of law.
It's a point of law.
Only in point of law.
আমার তো রেসপন্স নাম্বার যেটা তার নামটা লিখলাম petitioner MD Bora Standing Council Transport for response number 123. হ'ব?
আমাৰ বিল পামেই আমি আমাৰ বোলো বিল পামেই নাম নাহিলেও বিল পাম
ইমান কষ্ট নাম
মই নাপাওঁ মই ক'ত বিল
ইমান কষ্ট নাম নাহিলে বেয়া লাগিব।
নামটো আহিবই এইটো চিংগল পাৰ্চন আছে গোটেইখন বহুত গিলাই আছো
কথা কওঁ আমনি আপোনালোকৰ 1% হ'ব পাৰিলো হয়। I am just out
এই
here.
দেখিছ অপ্সৰা নামি আহিছে ওপৰৰ পৰা ফাইল
ফাইল কবা
মই দিওঁ ইপিনে থাকোতে কেছ আছে। দাদা মই এটা কথা কওঁ।
মিছ কৰি আছো মই